Hi, I'm Bernie, and joining me today is Mr. David Edney, a fairly prodigious barrister. And if I go through all of your accolades, we'll be here all day. So
I'll take prestigious. I don't know if anyone said that about me before. I'll take it.
Well, it's been said about you, but behind your back.
Now I don't believe you.
Yeah.
I don't believe you, Bernie.
All right. Well, welcome everyone. The Caselaw Club. All right. So today we have the matter of Aquatic Air Pty Limited and Siewert, number 3, 2018 case of the New South Wales Supreme Court, number 624. Now, this is sort of the final decision in a string of decisions, and the primary case has been ended. It's over. We enter this situation with a foregoing set of cases. We've had 4 set of plaintiffs, a couple of defendants as well. We've had numerous payments in and out of the court for costs, security costs. Some of those have been dispatched. Some of those have not. It's unclear what has and has not. Lo and behold, we get to the end of the case, and what do you know? There's a settlement. And I should say that one of the plaintiffs has dropped out, and there's some confusion about whether or not they have contributed costs and what their entitlement is and what the other parties are entitled to. So we get there, and there's an application for consent orders by one of the parties. And lo and behold, what do? They seek an informally letter, and they don't provide the prerequisite evidence. And the court comes back and they say, this could be a problem. How are we supposed to say whether you are entitled to this money or not? Although it seems, other people have been copied to the correspondence, but it seems that you are, saying you're seeking it by consent. How do we know that you're seeking it by consent? How do we know that that consent is appropriate?
I'm pretty sure there's a rule that to get money out of court, there's got to be an actual court order. It's some judge has to actually okay this. You can't just say, "Oh, can I have that money? Thanks." Works for me, but
well, you're a special case, Dave.
It's only with paying counsel's fees.
Yeah. Well, I think there was a request for payment to the solicitor as well, and there was an authorization to say whether the solicitor could accept it on behalf of the client, et cetera, et cetera. So it's a confusing, jumbled mess. Yeah. And the court has come back and said, no, tut, how dare you? Please revert with the appropriate steps. And they outlined the appropriate steps. And I might read directly from paragraph 10 of the case. All right. So the court reminded the parties of the well-established case law surrounding the strict requirements required for payment to be made for the court as in paragraph 10 of the judgment. So that's my note summary, but it's paragraph 10 of the judgment. As has been repeatedly emphasized, the entitlement to funds in court must be strictly proved, and notice must be given to any person who might have a claim on them. Before ordering payment out of funds of court, it is incumbent on the court to be satisfied that all those with a claim on the funds in court have been given notice and an opportunity to be heard, and the entitlement of those to whom the payment is to be made established. So 2 sets of obligations, the actual entitlement and other parties. The procedures applicable to payment into and out of court are intended to achieve these ends and should be strictly followed. Thus, in addition to evidence establishing the entitlement of the claimant, following must be established by admissible evidence. And David, I seem to notice one of these cases.
Yeah, I was about to. Minim XT?
Yeah. It seems like one of yours.
That was one of mine. That was before I was at the bar. I think I was on that as a solicitor. But yes, that is part of my experience of you kind of need to prove it if you want to get the money out of court. You can't just have some parties say, we want it. You got to actually, prove it, or at least prove that someone out of the group that has consented is the definitely entitled one to the money.
So it's not just, it's entitlement of the people who have consented as well.
Well, what you got to have is the court has to know that it isn't depriving someone against their will of money that they're entitled to. Minim XT was one where there was a whole bunch of parties, going back a bit, like 5 parties that were laying potential claims to this money. my recollection is all of us but one party reached a settlement on how we'll split it up. Rather than us fighting it out, we'll just divvy it up in a way that everyone agreed. And that one party that was out in the cold didn't have a claim. It was definitely behind collectively the others. Exactly where it lay in the priorities didn't matter, but on no view was it getting cash out of the pot at the end of the day. But it wouldn't sign on to the settlement without getting money. So the question was, in that case, how much did we have to prove to get the money out of court? And luckily it did work out fairly well. And the court said, look, we don't need to figure out who out of the 5 parties would have won this fight. It's enough to say the 4 that have settled, somewhere in there, they'd be the winners. They'd exhaust the fund. The guy who's getting nothing was never getting anything. So we'll give effect to the settlement of the 4. That's the gist of what happened in MinMXT, if I'm remembering it correctly. You'll tell me if I've got it wrong, but that was the gist of it. And that did work out fairly pragmatically, but it still took a lot of time and effort just to get that far, because as long as there's someone with a potential claim that hasn't signed on, and the court's going to make sure that everyone with a potential claim has signed on or has been shown to not actually have a claim, you got to go through the process, and it took quite a while.
That's really fascinating. Just so speaking generally, it seems like the court has to be assured that everyone who has any possibility of being entitled consents.
Well, that's it. Or is the one getting the money, because the court has the money. It needs to make sure it's getting to the right people. It's not just going to say, well, the first person who asked me for it can have it. So you have to affirmatively not just say that you've got a claim on the money. You have to tell the court, as part of any of these applications, why you're the only one with the claim with the money, to the money, or if there's someone with a potential claim that they've been notified and hopefully either consented or else been given a chance to show up and contest it. It's definitely not enough. I think some people do get this wrong, to just say, well, I've got a basis, so I've got a claim, so that gets me there now, because that definitely doesn't work. Sometimes that can be very difficult to prove in detail, because if you've got a whole lot of money going into court, the description you've already given, this has all sorts of cash going in and out with a whole lot of different parties. Not necessarily a straightforward exercise, but if you're the one who wants the money out of court, it's your job to be able to explain it.
Well, it brings up a very interesting idea that the court hasn't fully decided on a matter. It hasn't completed a matter. It hasn't come to, it hasn't made orders for the decision, for a final decision to decide whether or not the claim is appropriate. It's almost like striking it out.
Well, you're talking MinMXT or kind of scenario?
That scenario is what's making me think of this.
It kind of has, because it's, if the 3, 4, 5, whatever the number of parties that had consented in MinMXT, they have, for want of a better description, was collectively pooled their rights by agreeing between themselves where it all goes. So it really is a final decision on the merits, whether entitlement to the cash lies in the agreed pool or with the party who obviously isn't entitled to the money. Yeah. That is a final decision on the merits. There's no suggestion that, I'm pretty sure it was Black, could be wrong, didn't fully consider the potential claim of the fifth party. He did fully consider it on the merits and could see that they weren't getting the money. It was getting exhausted at the higher levels.
Yeah.
So therefore, on the merits, the consent could be given effect. And by taking that approach, all the parties that did agree saved a huge amount of time, money, and effort. The amount, I can't remember the exact dollar figures, but it was, I think, low 6 figures and quite low 6 figures in that case. So if you start having 4 parties all fighting to the death, you spend as much as you're fighting over. So it was a very sensible outcome. And I think the court could see the sense of that.
Yeah. With any kind of reasonable claim for a couple of parties on board, easily going over 6 figures. No.
Well, that's it. So the parties with claims that had a chance of getting the money struck a deal, and one party that was never going, may have had a claim, but not a claim that was ever going to prevail over the others.
Right.
May not have been happy about getting left out, but that's how it was and that's how it should be.
Yeah. That's interesting.
Yeah.
Go back to the case.
Go for it.
So the court specified the things that need to be done, and they made orders that was slightly different. But let's go over the judgment. They say, and I quote, that parties have to follow the steps. They have to identify by admissible evidence, and they establish by admissible evidence the amount of the funds in court, remaining in court, the circumstances in which they were paid in and by whom. And it's actually interesting that the amount of funds in court were different to what had originally been submitted due to interest accruing. And it's interesting to me. I'm not aware of a mechanism through which they could identify exactly what the funds in court were. Are you?
As a barrister, I don't have to deal with court registries that much or at all anymore. So I'm a bit out of the loop, but I'm pretty sure you've got to somehow get through to someone at the court treasury who may or may not be able to tell you. Look, the short answer is I don't think there's an easy way to do it.
Yeah.
I'm not even sure what the court's processes are with interest. It certainly used to be, I think the Supreme Court was very generous with paying interest. The federal court, you normally didn't get any unless you had special orders for it to go into an interest-bearing account. But I don't actually know because it's just a kind of logistical thing I don't have to deal with. But I don't know. I will say I've definitely been in cases where I've got away with identifying the principal amount, at least in simpler cases where it's just a single fund. You can say, here's the principal amount that went into court, and then you frame all your orders as that amount and any accrued interest, especially if the claim's proprietary, so that it's one party is going to get the entire fund, whether it have no interest or $1 million of interest on it.
Yeah.
I've definitely seen cases where that's...
Perhaps that wouldn't be a problem if there wasn't money taken out, put in, and numerous other omissions in the consent orders.
That will massively complicate it, and equally if it's for things like security for costs or so on.
Yeah.
In a cost sort of scenario where, well, hypothetically, if there is enough money there, it will affect where it goes.
Yeah.
Which is different from a proprietary case where if one person's got a claim to the whole fund, it doesn't matter how big the fund is, they get the lot. So
yeah. I think, look, this was a relatively small amount of interest. I think it was, off the top of my head, something like six grand or something like that, $6,000. Nonetheless, it was something the court identified.
Yeah.
All right, so the circumstance in which they paid in and by whom. So who paid money in? That's my reading of that. The name and address of each person who had an interest in the claim to the funds, or that there are no other persons with a claim, obviously. The notice has been given to each of them, other than those who have consented. And there were no stop orders under UCR 41.16. It seems pretty common sense, but it seems also like something that starting solicitors should be well aware of when they write to the court and seek these orders.
You'd be surprised.
I'm not sure I would anymore. Yeah.
Most of that makes sense. And a lot of that, I think, almost just falls into general ex parte duties. I mean, it's certainly everything that deals with potential third-party claims. If you're trying to get money out of court, you are probably, well, unless there are no other claimants, in which case you're saying as much, the moment there's any other claimant, you are seeking, at least in all substance, I would have thought, an ex parte order, which gives rise to all your ethical obligations, which is you have to point out these people, you have to basically bend over backwards to tell the court why you shouldn't be getting your relief. In practical terms, normally it should be for the person making a competing claim to come and advocate their own case, but a lot of this I'm not sure is in any way special to funds in court. It's just this is what you need to do if you're doing anything where there's potential third-party interest being affected.
Well, I think there was one of the parties pulled out as well of the proceedings, and the court made reference to them.
All the more so if they're not there, then
and potentially if the other, if you're dealing with potential bankrupts, I'm curious as to
you have to tell a bankruptcy trustee then.
Exactly. I'm not sure that was the case in this instance. I don't think it was.
But no, look, that's a good statement of the principle, though, because it's just you need to know this is with the process. A lot of people don't have to deal with getting money out of court. And just don't have the first idea what they need to provide. And in this case, it sounds like it was just sending a letter to the court saying, please, can I have all the money? Which, no, that's quite it.
Well, the court was, I think, a little bit charitable because they made conditional orders for notification to be provided with 2 weeks, and if no response was received, then the money would be released. But yeah, I thought it was an interesting little niblet of information.
I mean, the court doesn't want to be harder than they have to be either. They appreciate there's no point making people spend a fortune if they don't need to. But at the same time, they can't just be handing out money to people who aren't entitled to it.
Yeah, I mean, there's potential for abuse, but it's coming from solicitors. You could see if it was not solicitors, if it's a self-represented litigant. But I mean, these are security for costs mostly.
Security for costs would normally be a bit, well, even solicitors, you need to, I'm not suggesting solicitors would do something unethical, but at the same time, solicitors may not know about it. If they're not put to ask their client who else could have a claim here, they may not always know.
The club is saying that it's appropriate to have the checks and balances. Regardless. All right. That's an interesting little case. I think that's a good place to wrap up if you're comfortable doing it.
Sounds good to me.
All right. I'm Bernie.
I'm David.
Thanks for joining us. It's been the Caselaw Club. Sorry, I've read about a dozen cases in the last 4 days and, short amount of hours. So they're sort of bleeding together a little bit. But
They get that way.
yeah, they do. But yeah, no, I mean, these sort of ones are a joy to read because these are relatively short. This was great.